with disabilities. Moderating our session is Dr. Enoch Chilemba, who's a very good friend of the center. Dr. Chilemba is the deputy head of the Faculty of Law at the University of Malawi, Malawi's Chancellor College. He is also a lecturer and he lectures in disability law, human rights law, international law, and he's written widely around disability issues and children's rights issues, amongst other areas. So Dr. Chilemba will be moderating this session for us. Thank you so much, Dr. Chilemba, and over to you. Dr. Chilemba, you're muted. We cannot hear you.
Okay, Innocent, can you hear me now?
Yes, loud and clear, thank you.
Okay, because it was saying the organizers are not allowing us to unmute ourselves. So I think that was the reason for that. But thank you. I just want some clarification. How many minutes should I allocate for each presentation?
The presenters have 20 minutes, and then there will be time at the end for questions and answers and reflections.
So do I need to be warning them the time, or?
I think they are going above time. We should remind them so we can finish time. Yes. So please just let them know they are over time. I think presenters are aware of the time they have allocated.
All right. Thank you very much. So I just wanted to talk to the presenters. Do we have Beryl Orao? Beryl Orao and Paul Juma. If I can hear from Beryl Orao and Paul Juma.
Yes, Dr. Chilemba, I'm there. This is Beryl.
Okay. So are you presenting alone or you are presenting with Juma?
I'm presenting with Juma.
Okay. He's around, okay.
Yes,
and what about Dr. Uzoma Oparaku? Can I hear from?
Yes, I'm available. Good afternoon.
All right, thank you. Are you presenting with Dr. Ngozi Chuma Umei?
Yes, but she has a little health challenge, so she will be handling the responses at the end of the presentation, if that comes up.
All right. So Beryl, you are presenting first, right?
Yes.
Okay, then we'll go to Dr. Oparaku. Okay, so Beryl Orao and Paul Ochieng are students at the University of Pretoria. Beryl Orao is a PhD candidate, while Paul Ochieng Juma is a master's student. So I think it's a very good combination. We're looking forward to that. I think I'll just proceed to also introduce the second speaker. So Dr. Uzoma Prince Oparaku is a research fellow and the coordinator of the Public Health Law and Policy Research Project at the Nigerian Institute of Advanced Legal Studies, which focuses on research on public health law and policy, disability rights, and criminology. She holds an LLB from the University of Calabar in Nigeria. And she has a certificate on bioethics from the University of Wits. And she's also a solicitor and advocate of the Supreme Court of Nigeria. While Dr. Umei is a senior lecturer in the Department of International and Jurisprudence at Imo State University in Nigeria. And her research interests are disability rights, socioeconomic rights, socioeconomic justice, child rights, and sustainable development. She's also a member of the Law and Society Association. So you can see it's a brave and competent resume for each one of them. So looking forward to your presentations. So we'll start by the presentation by Beryl, which is looking at to what extent are global and regional jurisprudence on the right to health reflected in the jurisprudence of Kenyan courts on the right to health of persons with disabilities. So you have 20 minutes, Beryl and Paul, to make your joint presentation. Thank you.
Thank you, Dr. Chilemba, and good afternoon to you all. I'll not play my video because of internet connections, but I hope everybody can hear me. So I'll take the first 10 minutes to introduce the subject and discuss 3 cases on the subject. Thereafter, my colleague Paul Juma will take the next 10 minutes to discuss the approach of Kenyan courts in the application of international jurisprudence on PWD's right to health. So Tariro, if we could just go to the next slide. Yeah, so we'll start with an introduction, and then I'm going to set out what the CRPD says about the right to health and discuss the 3 cases. Thereafter, as I have said, Paul will discuss the approaches and application of international jurisprudence by Kenyan courts. So one may ask what the domestic importance of international jurisprudence is in the protection of PWD's health rights. These cases interpret state obligations under various treaties. In our case, the CRPD, and I should also say the African Charter. Due to the mutual dependency between international law and domestic law, there is a need for international standards to be reflected at the domestic level. In our paper, we argue that the failure to translate or adopt these interpretations at the domestic level may undermine the degree to which international law can actually enhance human rights protection, particularly the rights of PWDs. And there is a legal basis for the application of international jurisprudence by Kenyan courts. That is the Constitution of Kenya, which regards international law and national law as part of a single legal order. So since Kenya has ratified the CRPD, there is a strong case for the reflection of the CRPD Committee's interpretation of state obligations under the covenant in the jurisprudence of Kenyan courts. And that is particularly important because it adds value to the protections that are guaranteed at that international level. So next slide, please. Yes. So what does the CRPD say about the right to health of PWDs? I'll not go into the details of this, but I'll just say Article 25 requires states to recognize PWD's right to the highest attainable standards of health. And it further requires them to take measures to ensure that they have access to appropriate health services and goods. It then sets out some of the measures that states should take, among them, providing PWDs with the same range, quality, and standard of free or affordable healthcare as they do to other persons, providing health services needed by PWDs, particularly because of their disability, and that includes early identification and intervention. There are several others that are also listed under Article 25, but I'll not discuss them. I've singled out those 2 because they're directly applicable to the cases that I'm about to discuss. Now, how has the right to health of PWDs been interpreted at the international level? Tariro, next slide. So for the purposes of this presentation, we will focus on 2 decisions of the CRPD committee and 1 decision of the African Commission. As we found out during our research, the committee's jurisprudence is still quite thin. As of October 2020, it had decided or adopted views in 34 individual communications, and 2 of them relate to the right to health. Those are Munir Al-Adam and another versus Saudi Arabia, and HM versus Sweden. The African Commission's jurisprudence is also fairly thin, and in this presentation, we will highlight the landmark case of Purohit and another versus the Gambia. Starting with the Munir Al-Adam case, the brief facts, and I'm going to provide links to those cases in the chat box. The brief facts are that Munir had a partial hearing impairment acquired in childhood. The condition worsened as a result of torture by Saudi security agents and the failure by Saudi authorities to ensure access to health services by Munir, in spite of his repeated requests for such services. In our communication, an individual communication to the CRPD committee, Munir alleged that his right to health as provided for under Article 25 of the CRPD had been violated. And the committee found in Munir's favor and affirmed the positive obligation of states to address the health needs of PWDs in a manner that not only addresses their immediate health requirements, but also prevents or minimizes further disability. So remember, in this case, Munir already had a condition which could have been aided by medical intervention, which he was denied even after making repeated requests. In that case, the committee emphasized that in relation to PWDs in custody, states have a special responsibility to uphold their human rights. The use of the term special to us suggests a more compelling level of responsibility required of states where PWDs are in custody. In this regard, we argue that states will be held to a higher standard of accountability should a PWD's disability worsen as a result of the failure by the state to intervene early enough. The second case is HM versus Sweden, where HM had a disorder that severely affected her mobility. And because of her fragility, she could not be safely transported to hospital. And her specialist recommended a hydrotherapy, which would improve the quality of her life. She therefore applied to the local authorities in Sweden for permission to extend her house in order to build a pool for use during hydrotherapy, but her request was not accepted since Sweden had a local law, that is the Planning and Building Act, which would have been contravened had permission been granted. So in that case, the committee had to weigh between Sweden's obligations under the CRPD and the domestic legislation, which had very strict standards on issues touching on planning. The committee addressed the question of how the neutral application of laws may have discriminatory consequences for certain vulnerable groups, in this case, PWDs. In this regard, it recalled that the meaning of discrimination on the basis of disability under the CRPD is any distinction or restriction on the basis of disability which has the effect of impairing the enjoyment of human rights by PWDs on an equal basis with others. So in HM's case, the Swedish authorities' strict interpretation of the Planning and Building Act failed to take into account the significant challenges that HM had. On the face of it, and as argued by Sweden, the Act applied to everyone equally, whether they had a disability or not. However, the effects, and as the committee noted, the effects of the neutral application of that law were disproportionate to HM. The committee also stated that under Article 2.3 of the CRPD, the denial of reasonable accommodation is itself a form of discrimination. So having regard to the meaning of reasonable accommodation under the convention, the committee concluded that Sweden had failed to provide reasonable accommodation to HM by denying her permission to build the hydrotherapy pool. This decision affirmed that equality has to be substantive, meaning that the physical and social environment has to be adjusted to accommodate PWDs to ensure equality of outcomes. That applies to any form of governmental action, legislative action, or even interpretation of the law by courts. Lastly, I will briefly highlight the African Commission's decision in Purohit and another versus the Gambia. So the main complaint in this case concerned the mental health law in force in the Gambia at the time, that is the Lunatics Detention Act. In that act, it was the complainants alleged that the act neither defined a lunatic nor contained any safeguards concerning the diagnosis and detention of patients. There were also complaints about the general conditions of detention of mental health patients. So the African Commission found several violations of the African Charter, including Article 2 and 3 on freedom from discrimination and the right to equality before the law. In relation to the question of discrimination in access to health services for persons with mental disabilities, the Commission emphasized the need for the right of access to health services to be guaranteed to all without discrimination of any kind. It urged the Gambia to take concrete and targeted steps to ensure that the right to health is fully realized in all its aspects without discrimination. Yes, the Commission recognized that resources may be a challenge for some African states. However, it also emphasized that the utilization of the available resources should not be done in a discriminatory manner. For example, a state should not be had to argue that they don't have resources to ensure access to mental health services by persons with mental disabilities, yet the rest of its population can easily access other health services. So if priority is being given, then one aspect of the right to health should not be more important than another aspect of the right to health. So generally, these three cases set a very high standard for the protection of PWD's right to health. And the case of HM in particular, in terms of how how the committee interpreted a domestic legislation, which on the face of it was inherently okay, but whose application, if the application was neutral, resulted into a discriminatory outcome for a PWD. So these high standards is what we would want to see domestic courts reflect in their own interpretations of the right to health of PWDs. So next, we now see whether the reasoning in these decisions has been reflected in the jurisprudence of Kenyan courts, and my colleague Paul will take us through that. Paul.
Good afternoon, Dr. Chilemba. Participants, I'm now going to look at the approaches and application of international jurisprudence on the right to health by Kenyan courts. As my colleague stated, the entry point of international human rights jurisprudence on the right to health is Article 2.5 of the Kenyan Constitution, which allows for the application of international jurisprudence in Kenya's legal landscape. However, there are three approaches that have been used by Kenyan courts when applying international jurisprudence. And the three are the avoidance approach, the alignment approach, and the contesting approach. I will start with the avoidance approach. The avoidance approach, from the word avoid, basically means the rejection of the application of international jurisprudence on PWD's right to health and there are several reasons for using the avoidance approach. The avoidance approach is usually used because of economic constraints, lack of awareness, and lack of political goodwill on state authorities, on the part of state authorities. Then the second approach that has been adopted by Kenyan courts is the alignment approach. The alignment approach, from the word align, uses international human rights jurisprudence to effect change in national legal systems. The advantage of using this approach is that it prevents national laws from being in conflict with international jurisprudence. And then the third approach is the contesting approach, from the word contest. And it occurs when courts, national courts, departs from decisions of international tribunals. And there are several reasons for this. The first reason is where international jurisprudence undermines the dynamic and evolving nature of the treaty, or where the particular international jurisprudence is wrong or less protective than the state's constitution. So, which approach has Kenya taken when applying international jurisprudence, particularly on PWD's right to health? To answer this question, we considered two local cases. That is the Kenya Society for the Mentally Handicapped case versus Attorney General, and Matthew Okwanda versus Minister of Health and Medical Services, which I have quoted in our presentation. In the first case, that is the Kenya Society case, the petitioner was alleging that his right to health had been violated by the state because of the state's failure to implement various policies under the National Health Program aimed at preventing disability and identifying disability of persons with mental and intellectual disability. Further, the petitioner alleged that the state had failed to establish sufficient, reliable, and comprehensive structures to promote adequate provision of mental health care in public health institutions that violated PWD's right to health. After arguing the petition, the court dismissed the petitioner's claims, but with much sympathy. And in doing so, the court stated that it is not its function to prescribe policies, but to ensure that policies that have been put in place by the state meet the constitutional thresholds and are followed to the latter. The court also stated that where the state proves that it lacks adequate funds to provide for PWD's right to health, then the state duty to fulfill those obligations, the state will be exempted from fulfilling those obligations. Now, the reasoning in that case was followed in the case of Matthew, where the petitioner was claiming reasonable care from the state after being diagnosed with diabetes. The state also gave the court also gave the same reasons, that it is not its mandate to make policies and that the state had proved that it lacks adequate resources to fulfill those obligations under Article 25 of the CRPD. Now, those two cases never quoted any international human rights jurisprudence on PWD's right to health. And for that reason, the approach, we were of the view that the approach by Kenyan courts when it comes to the interpretation of international human rights jurisprudence on PWD's right to health has been the avoidance approach. Now, the main problem with the avoidance approach, particularly in Kenya's legal system, is that it greatly hinders the effectiveness of Article 25 of the CRPD. The approach hints at parochialism, which is based on domestic legal system without reference to any international jurisprudence. And since Kenya has not ratified the optional protocol to the CRPD, its citizens are left without recourse and it also means that the CRPD's interpretation of Article 25 cannot be felt by the inhabitants of Kenya. So, we made some recommendations, and in our recommendations, we were suggesting that Kenyan courts, when it comes to the interpretation of PWD's right to health, should adopt the alignment approach. The alignment approach ensures that global perspectives are reflected in the domestic level, because it is only at the domestic level that rights can be affirmed. Also, through mainstreaming international human rights jurisprudence, particularly on the rights of persons with disability, international human rights jurisprudence are made, or rather becomes binding on state authorities as opposed to the avoidance approach. Thank you very much. That will be all from my part.
Thank you very much for the presentation. I think you have set the pace very right. Bereo and Paul, you were just on time, and you have taken us through the journey of international and regional jurisprudence on the right to health, the decisions from the Committee on the Rights of Persons with Disabilities and the African Commission, the standards they have set for the right to health. And then you've talked to us about the approaches to application of international law in Kenya, those three approaches. And then you've also given us two cases, and how they have decided issues to do with human rights, especially the right to health in Kenya, whereby they made decisions the cases involved mental health care in public institutions, but they dismissed the matter without even applying international jurisprudence. So this was a missed opportunity because the Kenyan courts would have used the alignment approach or even mainstreaming. Was in the views of the presenters, much as the standards are set at the international level, but real realization and implementation is at the national level. So if we do at the national level, whatever we do without paying regard to what is obtaining at the international level, it's a missed opportunity. So we really loved your recommendations, but we know there is feedback. I will just ask participants to hold their peace. The time for comments and observations will come. For now, let's listen to the presentation by Dr. Prince Oparaku and Dr. Ngozi Chuma Umei. So they'll be presenting on discrimination against persons with disabilities and the Prohibition Act of 2018 and the imperatives of securing equitable access to healthcare services for persons with disabilities in Nigeria. I think they'll look at there is a right to free mental health services there, and then see the normative framework at the international level, and then how that can be used to eliminate the barriers at the domestic level. So we're looking forward to that presentation. And we believe you do it in 20 minutes as the first two presenters are. Over to you, Dr. Oparaku.
Okay, good afternoon, everyone. Thank you for the opportunity. We are grateful to the organizers and the moderator for this session. If it's okay, I will want to share my screen. That way I'm able to follow through with the structure of my presentation. Okay, can you see my screen now? Can you hear me, see my screen? Hello?
Yes, we can see this. Yes, we can see.
Oh, you can?
But
awesome.
The language, is it English, this one?
It's blurry. Okay. You can't actually decipher the text.
It is? Hmm.
It's blurry.
No, is it because of the size? Is it better now, no? Or is it worse?
It's the same.
Okay, it was the same.
It was the font style.
Okay. Someone is requesting to remotely control the screen. Let me see if the person is able to fix why it is blurry. Okay, is it better now?
No, no.
No.
Okay, maybe we can do without it. Is that okay?
Yes.
Not yet.
Hello?
It was the font type that was used.
Oh, is that what it is? Okay, I can change that now. That will take our time. All right.
Hello.
So
Hello,
so you want me to go ahead without sharing the screen?
I think that would be fine. You can present without showing the screen. Yeah.
Awesome. Okay, it's 1:38, so my 20 minutes starts now, if that's okay.
Yeah, it is. It is okay.
All right, thank you so much. Our topic is the Discrimination Against Persons with Disabilities Prohibition Act 2018 and the imperatives of securing equitable access to healthcare services for PWDs in Nigeria. I'll be presenting almost alone. However, my partner, Dr. Ngozi, is around and she's able to take questions as we progress when we get to that portion of the presentation. Yes, our research focus, aim, and methodology is, our presentation is focused on the Disability Act, the overview of what the situation was before that act was passed in Nigeria. We evaluate progress, what has been done to change the situation since the act came into operation and came into force. And then how do you know, which is what the conference is about, how do we make this right available to PWDs in Nigeria if that's not the case, even with the presence of the act? Our methodology is basically desk review and participatory observation. By way of introduction, the act was mostly pioneered by the ratification of the CRPD in Nigeria, which is preceded by rigorous advocacy by the PWD stakeholders, PWD rights activists in the country, people that pushed to make sure that the country sheds light and shows interest in the rights of PWDs in Nigeria. Before the passage of the act, okay, for the sake of background, Nigeria is a federal democracy. So we have states, federating states who have their own laws, who must domesticate international treaties even after the country domesticates the act as a federal law. So, however, from when Nigeria ratified this law at the international level, states in the country went ahead to actually domesticate this law even before the country itself domesticated it in an act, in a national law. Some even 10 years before the national law was passed. The act as it is mirrors mostly what is captured in Article 9 and 25 of the CRPD regarding the rights of PWDs. The act to administer the act is the National Disability Commission, created under the act, empowered to sue and be sued on behalf of PWDs, receive complaints from persons with disabilities, engage in public-private partnerships to ensure that these rights are, as enshrined under the law, is operationalized, collaborate with faith-based organizations, civil society organizations to protect and advance the rights of PWDs. The purpose of the act will, it demonstrates that the country seems to lean towards the human rights model of disability, but that's, remains to be seen as we continue in the presentation. I want to touch on a few health-specific provisions of that 2018 act that was preceded by the ratification of the CRPD by Nigeria. The act was passed in 2018, and some states, like I said, passed it much earlier than the national law, like Lagos State passed that law in 2011. There's Anambra State, Ogun State, Jigawa State, Bauchi. Quite a number of states has passed this law in the country, providing for different versions of what is envisioned under Article 25 of CRPD. The act's, intent to integrate PWDs into everyday life in the society by providing rights that will enable them live regular lives as much as practicable under prevailing conditions in the country. Part 2 of the Act under Section 3 to 8 specifically provides for the right to access public buildings, accessibility aids, ramps, and lanes for public places, roads, sidewalks, special facilities. The Act provides for a 5-year transition period to give, organizations, agencies of the government to, adapt their program, their buildings, and whatever they do with regard to PWDs to now fall in line with the law. However, it's been 22 months since this law was passed, and as we progress in the presentation, we will see if this has been done or where we are in getting this done. Under Part 5, Section 21 sub 1 provides for an unfettered access to adequate healthcare services and facilities for PWDs, and Section 21 sub 2 provides for free mental medical care, and Section 22 provides for certificate of mental disability, temporary or permanent for PWDs, to qualify them to receive services where they present the certificate. Section 23 makes it an offense to obtain this certificate fraudulently. Our research found, if you recollect, earlier I said that we're going to evaluate and see what is the situation in the country, what has it become, and in our research we found that before the act was passed, some states in Nigeria, of course, like we earlier noted, had passed this law, and this right to non-discrimination was provided under the Federal Constitution 1999. However, the posture of the federal government has been that these rights are not justiciable. And what do we mean by that? It means that the government cannot be sued to vitiate any violation of these rights of any sort. And this was the position of the government in a matter that they were dragged before the ECOWAS Community Regional Court in the case of Serap versus Federal Republic of Nigeria and the Universal Basic Education Commission. That matter actually was about the right to education. However, in Nigeria, that right is under that section, Section 6 sub 6 of the Constitution. And under that section, the government looks at it as a policy. It does not give a substantive or positive right that can be vitiated in any court of law in the country. And I'm sure that is why this civil society organization went to the regional court, because they knew that there was no way a local court in the country would even bother hearing the matter in the first place. Even when they do, that will still be their position, because that's what the Constitution says. Before now, the insurance scheme provided by the government, healthcare policies, strategic plans on AIDS, and other public health programs were not tailored to fit PWD. They were just regular programs planned for every citizen who fall under what the program dictates, or who may need what the program was providing for. And all this was in spite of these laws passed by state and by the federal government providing rights to PWDs. And ostensibly, the Nigerian government could appear like they are committed to a right-based approach to disability integration. However, this cannot be the case from what can be seen on observation. Particularly, stakeholders in governance lack any political or funding commitment or an understanding of ramifications of operationalizing a rights-based agenda to disability and inclusion. Some experimental decisions made in the country demonstrate that PWDs are not valued like every other Nigerian, as exemplified in some clinical trials that were carried out in the country that led to death of several children with disabilities. Most PWDs in the country lack access to specialist care in the country because there's no deliberate attempt to include them, whether it's by way of insurance or by way of reduced cost of care, which is what the Article 25, is concerned with, providing either free medical care or affordable medical care for PWDs. in our context, PWDs are not able to access public or private hospitals because they grapple with negative attitudes of health workers and unsuitable hospital facilities and installations that are not able to, that they cannot access because they were not built for this access. In our research, we also found that many IDPs in the country, PWDs included, do not have access to mental health care or social services or medical rehabilitation therapy. The ministry that was in charge of PWD programming before the passage of the Act and creation of the National Disability Commission, which is the Ministry of Women and Social Affairs, have staff that do not have a clear understanding of what it entails to advance a right-based approach to PWD issues. PWDs in the country do not have access to primary healthcare facilities that are readily available in rural areas. Even where they are, there are no doctors to attend to even able-bodied Nigerians, much less disabled patients. And then we want to evaluate progress. Where are we? If this has been the deplorable state of facilities, services, programming, where are we now? What has been done? With regard to unfettered access to healthcare services and facilities, we are at 22 months, and we ought to have a 5-year moratorium to get to where we are able to say, yes, we can provide for this rise. However, in a research, it was found that 80% of buildings in the country do not have access for PWDs, whether they are using assistive devices or not. 80% of these buildings have only stairs for individuals to access these buildings, and that cannot be sufficient to provide for access to these buildings for PWDs. I'm trying to get to my next slide. Adaptive transportation. In Nigeria, we have 3 major, most likely, means of transportation, which will be road, air, and sea. However, on close observation, the main means of transportation for Nigeria is by road. And in Nigeria, 22 months after the law was passed, we do not have any, the roads are not even good enough for able-bodied individuals to walk. Some roads do not have sidewalks at all. So we cannot be talking about whether they have ramps for wheelchair to access or for individuals who have canes to approach traffic and be able to use devices installed to cross the road safely. If you were seeing my screen, I had a picture of the major means of transportation in most parts of the country, which is a bus called downfall bus, which is unsafe even for able-bodied individuals to get on them. These buses do not even stop for people to get on. Most times they are still in motion while asking for passengers to board these vehicles. In some cases, we have tricycles and motorcycles, and these are not even safe for regular transportation and cannot be used for PWC's transportation. And this directly impacts on PWC's ability to get to hospital visits, to get access to healthcare where it is available. Access to built environment. The ability to leave home and access roadways is inexorably linked to equitable access to medical care. And that much is clear, because you need to leave your home to be able to access care. Nigeria does not have what you may have in other developed countries, where you have visiting physicians who are able to go to homes and provide healthcare services. So for a PWD to access healthcare, they need to leave their homes and get on the roadway to access these services. And therefore, where these roads are not built in such a way that PWDs are able to safely access them to get to these facilities, then they are not able to access the care at all, even when facilities are properly provided in the hospitals. The issues that PWDs face on the road include congestions. There are no pedestrian ramps, no proper signage, no lighting, no written information to or physical assistance by law enforcement for PWDs to actually get safe access and use of public roadways. And now I move on to our recommendations on how to increase access, on how to overcome these barriers that seem so daunting, even after this law was passed, providing all this, eloquent and beautiful rights for PWDs. And we recommend that using the lens of reasonable accommodations, which has been, spoken about by other presenters earlier in the day, that in the lines of barriers in housing, educational facilities and resources, hospital visits, public facilities, and all other variations, that PWDs are able to assess these rights if we begin to operationalize these rights through the lens of reasonable accommodations. If this law has been passed and at this point it has still not yielded any impactful or meaningful result for PWDs, then we can, by reasonable accommodations, make it easier, make it more impactful by integrating children that are PWDs into regular education instead of instead of providing for a separate educational system where there's school for the blind, there's school for children with impaired hearing or impaired vision. The country can begin to explore options through reasonable accommodations. Inclusive communities, the country can deliberately create programs, especially through the National Disability Commission, that anticipate the needs of PWDs, even at the point of the creation of the program, that you already anticipate that PWDs, the challenges they will have in their desire to use these services. After 22 months, facilitating the improvement of built environment to accommodate the needs of PWDs. This cannot be overemphasized. Ramps are even useful, even to citizens who are able-bodied. PWDs cannot. There's no way they can be integrated into everyday life without a tweaking of the built environment to adapt to the needs of PWDs. Investing in adaptive transportation. Again, that's what we've been talking about since morning. Transportation in Nigeria needs to get safe, even for the able-bodied. So it's a developmental issue that must be decisively addressed in order to eventually reach a PWD. Recruiting healthcare personnel with PWD health needs training, specific training. We also found from what we said earlier that healthcare professionals, more often than not, do not have the training they require to attend to PWDs. That way, it becomes a barrier when PWDs are able to overcome all the barriers on their way from home to the clinic, that when they arrive, they are not able to get health-specific, the care that's specific to their needs because there is no adequate one. I'm on my last, this is my last slide.
I hope you're wrapping up.
Yes, this is the last point on that slide, actually. Funding. We cannot be overemphasized that no matter what we recommend, without funding, without an aggressive funding commitment by successive administrations in the country, these provisions cannot be actualized. They must be funded, they must be funded, they must be funded to ensure that services are made available and adaptive to the needs of PWDs, and also to ensure that they are sustained thereafter. Thank you for listening.
Thank you very much for the presentation. So because of time, I'm supposed to summarize, but I'll not because of time. Yeah, but at least you've gone ahead to identify the barriers and also to provide the solutions. There are even tangible solutions which can be used to eliminate those barriers to equitable access to health. Of course, we are supposed to speak slowly so that the sign language interpreters can do it. But I think you were rushing because of time. So maybe to balance this, it was not that. Okay, so we're supposed to end the session at 3, which means we don't have like 5 minutes for comments, but I think we'll be able to do that. So can we have questions, comments, reflections from participants? I don't know how we do that. Is it just, you just unmute or? Yeah, I'm not familiar on how we have to do that. Or do you send the questions? Yeah, but let's have feedback. Can I ask?
Hello, can I go?
Yes, you can.
Okay, good afternoon.
Good afternoon.
My name is Teophilos and I'm joining in from Nigeria. I would like to thank the presenter, Dr. Uzo, on the presentation on the Act and all she said about health. I just want to get the opinion of the speaker about the content of the Nigerian law with regards to health or persons with disabilities. Looking at the law, it provides for persons with disabilities having unfettered access to health, no matter what that means. It provides for free medical services to quote and unquote persons with mental disability, and it also provides for communication provision for persons with communication needs. But besides this, there are other provisions in the CRPD that I feel the Nigerian law did not capture, especially things to do with, for instance, informed consent and other forms of support that persons with disabilities will require in the health sector. So would you now say that the Nigerian law is out to fulfill the CRPD, or is a watered down version of the rights provided for persons with disabilities in the CRPD? Thank you.
Do you want me to go ahead and answer, or you want to ask other questions?
Let's wait for one more.
Okay.
Yes. Yes, do we have any further comments? Okay, it looks like we don't have any, but there are some questions that are coming here. For example, there is patience. But anyway, there are comments. So perhaps on the chat, you can just look on the chat and see the comments. Innocentia or Tariro, I want your guidance, because the session is supposed to end now so that another one starts.
Yes.
I don't know how many more minutes we can extend.
I think a few more minutes to allow the questions or reflections made by the last speaker. If those could be addressed, that would be fine.
Then after that, we can close.
Yes, that's
okay. Right. Thank you. You are generous, Innocentia. Okay. So, Doc from Nigeria, you can address the intervention.
Okay, the question was the content of the right.
Yes.
And then we say if the Nigerian version or attempt at providing for this right is a watered down version or not. First of all, let me start with the content. It provides for an unfettered access to adequate healthcare. Nigeria did not provide for a free medical services or affordable medical services. So to that extent, you could say it's a watered down version. However, we must recognize that countries will not bite more than they can chew. Nigeria cannot, at this time, provide for a free right to free medical services. We can't even fund our regular healthcare. We're not able to do that at this time. So these things, you know, is a mixture of issues. So I imagine that these were the considerations of the draftsman when they were making that law. And my understanding of better access to adequate healthcare, to me, we have to be construed in such a way that it means that PWDs are able to access these facilities, that these services exist in the first place. That way, they are able to access them. And you also asked free, and what we provided in our law is free mental medical care. So they have chosen a category of healthcare that is free. In the country, we are doing very poorly by way of indices on mental health. Our mental health law is older than I am. I'm more than 40 years old, and that law is very old, since 1957. So maybe I'm again looking at the draftsman trying to mitigate that. Instead of waiting for that law to be passed, to be reformed, you know, they decided to bridge this gap for just PWDs in providing for free mental health care. And to that extent, I think that we attempted what we are able to do at this time. Eventually, as Nigeria gets developed, as we get more prosperous, like the countries that are able to provide for free medical care for a class of their citizens, I think we'll be able to do that. However, on the state, Lagos State particularly provides free medical services for PWDs. Again, why I was saying at the end of my presentation about funding. There's no will to fund these visions. So I would rather the provision read what it is in the Federal Act. That way, let the services exist in the first place. Let them have access to built environment. Let them have access to proper housing that has ramps. Let them be integrated into life first, before we start free health service. Thank you.
Doc, as you're wrapping up, yes. I think I should be giving you minutes in which to respond. You're speaking like an activist who speaks forever. Okay, so there is a view here, yes, which says, you talked of funding and all what you have mentioned there, but unless Chapter 2 of the Nigerian Constitution is amended, then all whatever we are saying here will be in vain. So I just want your view on this one, and I'll give you exactly 1 minute. So the view there is that unless, this is Patience Otumodon, a member of the Association of Lawyers with Disabilities in Nigeria. So this one is holding the view that whatever we are saying, unless Chapter 2 of the Nigerian Constitution is amended, all this will be in vain. So can you just use 1 minute to share your comments on that?
I beg to disagree. The government passed the law on disability rights. And if the government has the political will to operationalize the law as it is, we will overcome to a great extent what is anticipated in Chapter 2 of the Constitution. We don't, PWD is actually, if Nigeria is not a litigious country, we are not given to litigation. So it's not necessary, it's not all that wonderful that we can go to court and say our right is valid. And so what? After you go to court, so what? They do not even obey injunctions from the courts. So it doesn't really change. And if the government can fund that act as it is, PWDs, their situation in the country will be greatly improved if it's implemented as it is, funded and implemented, staffed as it is through the commission. The situation will be, if not completely wonderful, however, at least 80% will be much better than it is today.
Okay, thank you for sticking to. So I think that's an area for further debate and research, and we'll leave it that to next time. All right, thank you very much, presenters and participants. And you can also look at the chat. Indeed, there is a lot of discussion going on there. And I think at this moment, we'll end this session. and I hand over to Innocentia so that we look forward to the 3 o'clock to 4 o'clock session. Thank you very much. A round of applause to everyone.
Thank you so much, Dr. Chilemba, for moderating the session for us, and to all the presenters that really gave us insights on some of the cases that have been decided on our continent in terms of the right to health, and in what ways those cases advance or don't advance disability rights on our continent. So our next session, which I'm sure a lot of us have been looking forward to, is the issue of financing healthcare of persons with disabilities in Africa. Moderating that session is Ms. Afia. Sorry, let me just pull up her bio quickly. Yeah, so moderating that session is Ms. Afia. So she is the Equality, Justice and Human Rights Program Manager at Open Society Initiative for West Africa. She's based in Dakar, Senegal. She's responsible for the strategic development and management and grant making of the Osiwa EJHR program portfolio. She's from Ghana. She's done a lot of work around protecting the rights of vulnerable groups. And she's a very dear friend and supporter of the work we do here, the Disability Rights, but generally at the center. So thank you so much, Afia, for joining us and for facilitating this really interesting session around, how do we actually finance this? Over to you, Afia. Afia, can you hear me?
Hi, Innocentia. She was on the call, but I think she's lost connection, so she'll join us shortly, I'm sure.
Okay. So we'll just give her a few minutes to reconnect because I did also see her. But just to speak a little to her, to the session and the presenters, that the first presentation is going to be looking at financing reproductive health programs for persons with disabilities in Kenya and how we move beyond the rhetoric. It's going to be presented by Professor Edwin Abuya and Naomi Juguna. And then we have a follow-up presentation that's going to be on assessing the protection of the right to health of persons with disabilities in Mauritius, and looking at welfare state practice versus constitutional protection. And Dr. Ropanand Mahadu, sorry, I hope you're pronouncing it properly, is going to be giving that presentation. And then the last presentation will be by Benedict Muyomi, who's going to be looking at the nexus of disability, poverty, and health inequalities for persons with disabilities in Kenya. So I'm just gonna check again if Ms. Afia has, yeah, I see that she's trying to join. Afia, hi.
I'm sorry, I really apologize. I have no idea what has happened. I was listening to the previous session, and just as you were introducing me, my line, my Zoom just froze. I'm sorry. I have joined. I'm on my phone. I will try to reconnect on my laptop, but we can continue on via here since it is clear, please.
Yes, thank you, Afia. Please, please continue. I had just gone through the presentations, but I hadn't introduced the presenters and their bios.
We'll do that. Good afternoon and welcome to this very important session on financing healthcare with disabilities. Colleagues, friends, participants. My name is Afia Santua Sariche, and I work for the Open Society Initiative for West Africa, based in Dakar, Senegal. I'm very honored to be part of this conference, and it is truly my great pleasure to moderate this session. Now, before we continue, I'd just like to remind all of us of an important housekeeping matter, which I'm also guilty of because I just realized I've been speaking a bit fast. We have sign language interpretation, so please speak clearly and pace yourself when making your presentations and your comments and contributions. Also, we encourage everyone to show your reactions to presentations or statements by typing into the chat panel at the bottom right of your screen on Zoom. By doing this, we hope everyone can actually see some of the reactions to the presentations in real time. Thank you. So financing healthcare for persons with disabilities, I think remains one of the biggest challenges we have on the continent. And the situation has only been exacerbated by the COVID pandemic. Some African health financing efforts rely even on donor funding. And in the context where priorities rapidly change with these donors, and very often some of these efforts are not even formally recognized nationally, it leaves most, especially the persons with disabilities, without secure funding for their health care from governments. So this session will present case studies from two countries, principally from Kenya and Mauritius, on financing policy options that exist. How might these existing policy options not expand in scale, improve efficiency, questions around their effectiveness, and how do we truly make it sustainable? So we have with us Professor Edwin Abuya, Ms. Naomi Juguna, Dr. Ropanad Mahaju, and Ms. Bernadette Muyomi. I will introduce them shortly, starting with Prof. Edwin. So Professor Abuya is a human rights expert and has various expertise in the field of human rights, but his specialization is really on vulnerable populations, including persons with in Australia, in the United Kingdom, has done a number of have actually been. Professor Abuya, are you there?
Sorry, so this is Naomi Juguna.
Okay.
Yeah, Prof is indisposed,
Okay.
so I will be doing the presentation today.
Thank you, Naomi. So let me introduce you then. Ms. Naomi Juguna is a lawyer, an advocate of the court in Kenya. She has specialization in both labor law as well as in health law. She was admitted to the bar in Kenya over 14 years ago, so a lot of experience. She's currently a lecturer at the University of Nairobi, where she teaches labor law, medical law, and ethics, and health law and policy. Naomi will be speaking to us about something very, very interesting, which is financing reproductive health program for persons with disabilities in Kenya. After Naomi, we'll have Dr. Ropanad Mahaju from Mauritius. Now, Dr. Ropanad is a lecturer at the Department of Law, University of Mauritius. He specializes in international human rights law and public law. And he holds a doctoral degree from the University of Western Cape. And his thesis was actually on land grabbing in selected African states from a human rights and a developmental perspective. So welcome, Dr. Ropanad. The last person that will speak in this session will be Ms. Bernadette Muyomi. Madam is a social justice advocate and a disability rights scholar. She has a varied background and training. So she has background in guidance and counseling, in nursing, in development studies, and now in disability rights. So a fully well-rounded activist and a social justice advocate. Bernadette will speak to us later in the session. So Naomi, if you don't mind, I will start with you. Now, about a year ago, just about a year ago, actually, I was in Nairobi for the International Conference on Population Development. And the summit sought to address a number of issues. And one of the key issues that was on the table then was on sexual and reproductive rights. And how persons with disabilities, we advance this for persons with disabilities. We are also aware that the Kenyan government rolled out the Universal Health Coverage Program that sought to anchor it on the Constitution. So your Article 41 that guarantees that everyone should have the highest attainable, standard of health care, including the right to reproductive health. Kenya is also, of course, a signatory to the Convention on the Rights of Persons with Disabilities, CRPD. And then you guys did very well because based on the outcomes and the resolutions of the ICPD 25, Kenya then introduced a new health bill that is aiming to really provide a robust framework for the facilitation of access to reproductive health services for persons with disabilities. But there's a huge gap in this bill. So it is great to propose this legislation, which, by the way, is still being debated. But there is no financing policy in this. So the huge gap is your financing strategy. How are you going to finance this proposed legislation? So could you speak to us, enlighten us on what are some of the obligations that are being proposed to be imposed by this new law? What are the financial initiatives that has to be put in place to meet these obligations? And what will be if at all, remedies that will be available to aggrieved parties? Thank you, Naomi.
So thank you very much. Thank you, Afia, for that introduction. I hope that I can be heard. I'm sorry, I will not put on my video at the moment because of connectivity issues, so that we don't get too many interruptions. I don't know if...
Naomi, can I interrupt you, please?
Yes.
We have 1 hour and already the last session really ate into our 1 hour. I'm hoping that Sentia will be generous like she was to them and give us a couple of more minutes. But can I ask that maybe you speak to the paper in about 10 minutes and 10 minutes for each speaker, and then we'll come back for another round, time permitting, and also invite participants to engage with us. Will 10 minutes suffice?
Okay, I shall try.
Try,
so
thank you.
Do you want me to present my whole paper in 10 minutes or do you want me to present half of it?
maybe speak to the paper. Speak to the paper, please.
Okay.
Okay.
All right. So thank you very much. And I think what you've kind of laid out has made my work a little bit easier because those are the issues that the paper speaks to. And maybe I would start by saying that the effectiveness of any well-intended policy depends on its impact on the lives of the recipients who are going to, or who are supposed to benefit from it. And then impact is then determined by how well that law is financed and how well it is enforced. So we've talked about enforcement in the previous section with regard to justiciability of rights and how the courts enforce these rights. So this section then talks about this second pillar, which is the financing. And as Afia has said, in November last year, Kenya was privileged to host the ICPD at 25. And the theme of this particular conference was accelerating the promise. Of course, the promise being that there would be a recognized reproductive health protection and empowerment of women. There was focus, again, as Afia said, on the realization of sexual and reproductive health rights of persons with disabilities. Next slide, please. So in terms of the context in which we are in as a country, I think the ICPD at 25 came hot on the heels of our national census in August last year. And maybe just to give some context is that about 2.2% of Kenyans live with some form of disability. Majority of those are women. And again, majority of those live in rural areas. So these particular statistics are important in terms of looking at the strategies for financing. Next slide, please. In terms of looking at financing, I think it is important for us to recognize the intersecting factors that need to be considered when looking at persons with disabilities. And these factors are the ones that may increase their vulnerabilities. At the end of the presentation, I do make a specific recommendation that some intervening or some integrative health financing strategies that take into account these intersecting factors needs to be put in place. So poverty, literacy levels, sexual orientation, and of course, other stigmatized conditions such as HIV, all intersecting factors that health financing needs to take into account. So in terms of the specific challenges, if we move to the next slide, is that in Kenya, there are regional disparities in access to modern contraceptive methods and family planning methods, such that, for instance, in the central part of the country, there is 80% coverage of MCM. But in the northern part of the country, there's only 2%. But nationally, we look good. You know, we look good at 58% coverage. But these regional disparities are not being dealt with, even by our devolved system of health governance. There's a high burden of HIV infections amongst adolescents and young people. And so if you look at the statistics, more than half of all new HIV infections are amongst young people aged between 15 and 24. There are also preventable maternal morbidity and mortality issues, unsafe abortions, obstetric hemorrhaging, and such kind of preventable issues. The COVID-19 pandemic has presented a unique challenge for us in the country because there's an increased percentage of teenage pregnancies. I don't know what's happening in other countries in Africa, but within a 3-month period of time, from the time of lockdown, which was around March, within 3 months, we had about 152,000 teenage girls becoming pregnant. And of course, we can't overstate the issue of gender-based violence, rapes, defilements, particularly for girls and women in refugee camps, IDP camps, who are particularly vulnerable. And the statistics are quite clear on the increase from last year to this year on teenage pregnancies. So the consequent commitments from the ICPD 25 were made against a backdrop of international, regional, and domestic obligations on the right to health. So because of time, if we skip maybe about 2-3 slides, because what I've set out in the other, Afia has given me, so I have to make my submissions very quickly. So, I mean, those commitments are set out in our paper. But amidst those commitments, there's this robust framework, very romantic, I would say, a very romantic framework of international and regional obligations, which I think we are all familiar with. If we move to the next slide, we will see the domestic obligations that Kenya has. So we do have quite a number of statutes which provide for financing and the obligation of government in terms of resource allocation, the division between national government and county governments and their role in financing of healthcare, and particularly reproductive healthcare. So as Afia said, the Reproductive Health Bill, quite a controversial piece of legislation that is still being debated, but does not seem to address the issue of what strategies we need to have in order to finance healthcare. I won't go to the policies, but I've put them there and they're detailed in our paper. But just to go quickly to the initiatives that the government has put towards reproductive health service improvement. And one of the most robust ones is what is known as the Linda Mama Initiative, which is a free maternity health package that targets all pregnant women who are citizens of Kenya. And it covers a range of services such as antenatal, postnatal, complicated deliveries, as well as outpatient for infants up to 1 year of age, which looks very nice. But the criticism of this is that this is at the national level. The NHIF, the National Health Insurance Fund, is a program that is run at the national level. Yet health has been devolved to the counties. So all this money is being put into this corporation instead of being sent to the counties where health is supposed to be delivered and where issues of persons with disabilities and their sexual and reproductive health rights can actually be dealt with. The other initiatives, if we move to the next slide, is of course the Beyond Zero campaign to complement government efforts and digital technology innovations that reach adolescents and young people. Now, having said that, I know I've actually finished my 10 minutes, but if Afia, you'd just give me about just a few, like 3 more minutes, and I'll see how fast I can go. The vehicle that health financing in Kenya is to use is the Universal Health Coverage vehicle. And it is part of the government's Big Four agenda. In fact, I would say it is a political flagship project, a legacy that perhaps the incumbent government wants to use to leave a good legacy. But beyond the ribbon cutting and beyond the confetti and the launching of conferences and programs, we need to ask ourselves what the issues are and what the challenges are with regard to this. So if you could jump about 2 slides to the conversation points, the next slide, yeah. So the issues are, first, if we're talking about health financing for persons with disabilities and their sexual and reproductive health rights, we need to consider the sourcing of the funds, as Afia rightly said. And what is going on is that there is a transition from donor funding to domestic funding. So there's a reduced funding from the donor community. The US, which was a very strong partner under the Trump administration, came up with the Mexico City policy, or the Global Gag Rule, which prohibits funding to NGOs that offer counseling or referral services for abortion. And then domestic funding is also compromised because of the low tax base of its people. And therefore, this also speaks to the budgetary allocations and the priorities. During this COVID-19 season, the priorities have gone to PPEs, and rightly so, have gone to PPEs and enforcing that particular aspect of healthcare. So sexual and reproductive health issues have kind of been put on the back burner, but yet the vulnerabilities of PWDs are actually real, especially for persons with visual and even audio disabilities, because they rely on touch, they rely on lip reading, and so the issue of masking, becomes a challenge. So they're competing patient groups within the budgetary allocations. And I think because there's so much stigma that is attached to the sexual and reproductive health rights of PWDs, and they're seen as asexual, or they're seen as incapable of raising families and having a healthy sex life, then the priority is not really there. Next slide, please. So we also talk about sustainability and monitoring and evaluation, especially in the recent past, where we have seen a lot of corruption within the health programs, so that donor funding has come in, but the accounting of those funds it can't be done. So the areas of intervention are, of course, if we move to the next slide, Tariro, the areas of intervention for financing of SRHR, especially for persons with disabilities, of course, geographical access in terms of, avoiding the long distances to health facilities, especially in the rural areas. There's need to invest in educating persons with disabilities on how to access healthcare services digitally if they're not able to physically reach these health facilities. There's, of course, the issue of financial access. So in as much as user fees have been abolished, particularly for maternity care, there are still financial implications for drugs and for other family planning commodities. In some cases, patients have been detained for failure to pay their hospital bills. And then non-medical costs, transport costs. So if a person with disability needs assistance at the health facility, they would need to not only pay their transport costs, but also the transport costs of the person who is going to assist them. And of course, access to health information, there needs to be investment there so that it can be in accessible formats. Afia, do I still have a few minutes?
30 seconds to round up, please.
Okay, so should I just go to my last slide?
Please.
Okay, all right, very well. So we can, yeah, Tariro, help me. Right, so let's look beyond rhetoric. As I said earlier, there's the issue of the role between national government and county government. And county governments have been empowered by the Constitution to provide health services, including reproductive health services. So in terms of what national government should do and what county government should do, their roles should be clear so that monies should be channeled to the right level of government for to support these particular programs. The policies also should be amended. Okay, the policies that I referred to earlier, perhaps, which would be seen better in the paper, should be amended to provide specific interventions for persons with disabilities. So they're very nice and they talk good language, but PWD, the PWD agenda has not been completely checked in. I talked about inclusive health financing strategies that take into account the underlying determinants of health. And I think for us, for those who are lawyers, strategic litigation is also one of the ways of that health financing needs to take into account. How so? Funding for particularly persons with disabilities who are indigent and who do not have the ability to access the courts. And of course, finally, health resource tracking mechanisms to enhance accountability of any funds that come from the international community as well as from the domestic level. And I rest my case. Thank you.
Thank you very much, Naomi. And I'm sorry I had to rush you, but we are. Time is the eternal enemy. But thank you for raising a number of issues, you know, the importance of what policy or legislative effectiveness, depending essentially on how it impacts or affects the lives of people. 2.2% of the Kenyan population are persons with disabilities, and most of them are women and rural. That is a very important point. And I absolutely, being a student of critical race feminism, the concept of intersectionality and how policies and legislations have to have an intersectional approach and analysis to them. And then the issue about the devolution of power, clarifying the roles and responsibilities of national government and county government. And then, of course, the whole rhetoric and the reality. So there are all these wonderful initiatives, but are they inclusive? Are the people accessing it, especially those that are in the rural areas? And the importance of access cannot be overemphasized. It's not just physical access, there's digital access, access to health information, and all of that. And then, of course, once all these monies, whether it's donor funds or national government allocations, how do we ensure that we track them so that there is a transparent and efficient and judicious use of those resources? So thank you very much, Naomi. We will now move on to Dr. Rupenat Mahadu from Mauritius. Now, Mauritius has a slightly different approach. So we all know that, in a number of governance indexes, Mauritius is always one of the countries that is doing very well. And this is not misplaced, at least from right from their independence. They have had a national health policy that really tries to provide national health, free health services to everybody, especially persons with disabilities. The Ministry of Health in Mauritius has taken some measures that include, even among other things, priority service in hospitals. Persons with disabilities have certain amenities that is for them. So collection of medicines at pharmacy, home visits by nurses, and all of these things. But, they are laudable as they are actually, it's more of a welfare approach that they are using, as opposed to it being situated in a legal framework. So Dr. Mahadu actually argues or thinks that the most effective way for Mauritius to deal with the right to health of persons with disabilities is by enshrining this right to health in the Constitution, and it shouldn't be a part of a welfare system, because any government that comes in, depending on budget availability, may just say, well, we are no longer going to continue doing this because it is not situated, it is not grounded in law. So Dr. Mahadu, please enlighten us further on this, contestation between the welfare state practice versus a constitutional protection. Thank you. You have 10 minutes.
Okay, thank you very much. I wish to thank the Center for Human Rights as well as the organizers for giving me this opportunity. I am really honored. So my topic, as you clearly mentioned, is about making an assessment concerning the protection of the right to health of persons with disabilities in Mauritius. So it's about assessing the approach of welfare state practice versus the need to have constitutional protection. Mauritius is regarded as one of the strongest economy in Africa. And with this background and with the level of, and the degree of welfare state that we have, as you have clearly summarized earlier on, one would have expected that this whole question of financing healthcare of persons with disabilities should have been one which is adequately addressed in Mauritius, which is already a system which is well into practice and very much functional. But as a Mauritian myself, I am quite saddened by the state of affairs concerning, let alone the financing of healthcare of persons with disabilities, but with the whole legal framework concerning persons with disabilities. And I'm not restricting myself only to the right to health here in particular, but it is in relation to most other socioeconomic rights, including the right to education, to housing, and so on and so forth. rapidly, I think it's important for me, taking into account the few minutes that I have, to give you a background. So out of a population of 1.3 million, we already have around 60,000 people living with disability. And here I would wish to highlight that these figures that are being projected up here comes from a 2011 population census. So at the very outset, I have to stop here and to say how critical it is to obtain information, to obtain data when it comes to persons living with disability. The Committee on the Rights of Persons Living with Disability of the UN have clearly highlighted this as a serious lacuna, in the sense that collection of data is not as it should be when it comes to Mauritius. Out of this 60,000 people living with disability, women would consist of nearly 51%. And then we have also a good number of children who would be living with disabilities that will round off this particular figure. In terms of the prevalent forms of disabilities, physical disabilities would be the most prevalent one. And then this would be followed by persons with visual impairments, as well as persons having impairments and difficulties in terms of remembering, concentrating, or acquiring education and learning, which we can consider as a disability. So in terms of the international obligations that we have as the state of Mauritius, we have ratified the UN Convention on the Rights of Persons with Disabilities in January 2010. But it is to be noted that we have placed important reservations on articles such as the ones dealing with accessibility, situation of risk and humanitarian emergencies, equal recognition before the law, access to justice, and education. So these are reservations that have been placed, and we are nearly a decade in the future, but then not much effort has been seen from the government with regards to assessing whether there is a possibility of removing those reservations or not. Coming to the protocol to the African Charter on the Rights of Persons with Disabilities in Africa, I think it is also important to highlight that it has not yet been signed by the state of Mauritius. In terms of legislations, the next slide will give a list of a quite long list of legislations concerning persons living with disabilities. But I would say in summary that none of those legislations would actually, in a positive sense, give any particular right, let alone the right to health of persons living with disabilities. They would be more administrative in nature. So in that sense, credit to the different governments of Mauritius who have come up with these legislations to look at a few areas, especially education, training and employment, social aid, with regards to persons with disabilities. And as you might have guessed, all these legislations are framed around the welfare state approach. So in that sense, the government proceeds by way of taxation, and then out of a consolidated fund, amounts of money will be geared towards looking at some of those areas, as I mentioned, but not necessarily in terms of any attempt to protect, promote, or fulfill the substantive rights of people living with disabilities. Maybe one of the legislations that we may dedicate a few minutes on would be the Training and Employment of Disabled Persons Act 1996. So in a nutshell, it provides for the legislative framework on education of disabled persons, on employment of disabled persons, on school equipment. There are also provisions that speaks to the need to prevent discrimination, as well as setting up dedicated authorities. But while all these provisions look quite interesting, but it's difficult to use those legislations and to approach the government in terms of indicating to them that it is their responsibility, it is their legal duty to uphold the rights of persons with disabilities from any socioeconomic rights perspective. So one of the major criticism of those legislations is that there is an over-reliance on the private sector as well as on NGOs, what we call voluntary organizations. So too much of reliance would be on them to ensure that some of the provisions of these legislations are actually put into practice. So for instance, according to the Training and Employment of Disabled Persons Act, any company or any commercial entity which employ more than 35 persons, they have an obligation to employ also a number of people prescribed by the law that would be living with disabilities. But then if a survey is carried out, then it will be very clear that these provisions are not necessarily respected, and that very few companies or business entities would adequately follow those provisions. So this becomes an example of having some sort of legislations, but then with all the difficulties of translating them into reality and materializing whatever they propose in favor of persons living with disabilities. Quickly, regarding the question of discrimination, so we have the Equal Opportunities Act that prohibits discrimination on the basis of impairment. The Workers' Rights Act of 2019 also follows suit, and it has a similar provision. But then my next slide will indicate to you that none of these legislations have been aligned with the Constitution of Mauritius, or rather, I would say the reverse. The Constitution has not yet been amended to ensure that impairment or disability is an important basis on which discrimination is prohibited in Section 3 and 16 of the Mauritian Constitution. So if you open the supreme law of the country today and you look at the substantive provisions on discrimination, disability is not to be found anywhere. And even as I said, the concept of persons living with disability recognized as a vulnerable group, which perhaps would need some special attention. So none of these concepts have been enshrined in the Constitution. In terms of policies and institution, as you rightly summarized earlier on, we do have quite a number of them in the form of action plans, in the form of policy paper, some of them general and some of them that speaks to a specific.
Dr. Mahadou, vous avez 2 minutes pour finir.
Okay, merci. Merci. Donc, some of them in general, but some of them speaking quite specifically. So since I have only 2 minutes, let me come directly to the question of financing. So we do not even have a single action plan or policy paper that talks about specifically how the healthcare of persons living with disability is supposed to be financed. We rely on the welfare state system that is, every government, okay, I wouldn't say only to win votes, but let us give them some credit and say out of their own political will, they will dedicate a budget to financing healthcare of the population. And specifically of persons living with disability. But then there is nothing specific, there is no specific approach in that particular direction. So just like everybody enjoys the free healthcare, ranging from the most simple type of medical intervention to the most complex one in Mauritius. So in the same way, persons living with disability, they also benefit from that. My main argument is that, all the legislations that we have looked at, they are not constitutionally protected. In that sense, if we have a change in government that looks at the whole question of disability in a different way, so a simple majority would suffice for them to change it. And sometimes, as we have seen with the COVID-19 sanitary pandemic, sometimes there can be also natural causes which will force the government to take some drastic and negative action that will not benefit persons living with disabilities from a right to health perspective, as well as from other socioeconomic rights perspective. The absence of socioeconomic rights in the Constitution, and especially the right to health with regards to persons with disability, does not allow for any sort of constitutional challenge before the court. The Supreme Court, which is the apex court of the country, is not mandated at all to hear any such matters. So in that sense, if a particular policy or program is not aligned with international standards in relation to healthcare of persons living with disability, there is no possibility of challenging it. Second issue is that we are very bad when it comes to domestication. So a few international instruments that we have ratified that provides for socioeconomic rights in general, as well as in the context of persons living with disabilities, none of them have been domesticated. And since we are a dualist state, it means that none of those provisions can be invoked before courts, right? Finally, the question of financing is also, to be posed to not only the government, but as well as civil society organization, and to every single individual, every single citizen of the country. So here in Mauritius, there is a complete lack of culture in terms of strategic litigation. There is, it's as if we take things as they are given to us. We believe that, okay, this is the amount of money that has been dedicated to persons living with disability. So perhaps the government cannot do more. There is that apprehension to challenge policies of the government in relation to right to healthcare of persons with disability, which altogether makes it quite difficult for the agenda on financing of healthcare of persons with disability to be driven forward in an efficient manner, as would be the case in other African or non-African states. So, in summary, what we look at from outside or on the surface, being Mauritius as being a strong welfare state, giving with lots of things for free, maybe is not the reality of the situation on the ground. There are lots of hurdles, especially legal in nature, that is seriously blocking the agenda on persons with disabilities in general, as well as with regards to the right to healthcare, which is a major issue right now in the country.
Merci beaucoup. Merci, Dr. Mahadou. Thank you very much. Quick thoughts from your presentation. One is the normative power of language. I noted that in a number of your somewhat very outdated pieces of legislation, they refer they talk about disabled persons. Now we don't use that language anymore, and so I'm hoping that some of these pieces of the legislation is going to be, reviewed and put in the right language, because even in seemingly progressive countries such as Mauritius, it's disheartening to see some of the language that is used to refer to persons with disabilities. The fact that there is no constitutional reference to persons with disabilities is also something that I find quite shocking, because I've always looked at Mauritius as, being somewhat reform-minded and progressive. And then, of course, the welfare approach, laudable as it is, in a way, it's almost like handouts. Okay, we'll give them this, we'll do that. But there has to be a comprehensive constitutional inclusion and national legislation that recognizes the rights of these people, and legislation that is, it's acceptable and current with human rights, existing human rights standards now. But I note out of your 1.3 million, there is quite a bit of persons with disability in the population, even if this is almost a decade old census. The importance of data, you cannot, you can't care for people you can't count. It's simple as that. If you can't count the people, how are you going to care for them, or how are you going to make policies that respond effectively to their needs? So these are some of the things I noted from your presentation. Thank you very much, Dr. Mahamadou. And we will move on to our last speaker, Ms. Bernadette Muyomi. Bernadette, you have 10 minutes, please.
Okay. Thank you very much. I would like to share my screen.
Bernadette, you can request again.
I would like to share my screen.
You should be able to share now.
Okay, thank you. Okay, thank you very much. Thank you very much for this opportunity. I will focus my presentation titled The Nexus of Disability, Poverty, and Health Inequalities for Persons with Disabilities in Kenya. That is the topic of my presentation. And the main argument that I bring forth in my presentation is that despite Kenya being a signatory to the CRPD and having many non-discriminatory clauses in the Constitution to safeguard the rights of persons with disabilities, it still limits their access to healthcare, and this is because of the social and political inequalities that discriminate against persons with disabilities in regard to health financing. In looking at this presentation and in preparation of my paper, I focused on health in terms of three main issues: the ability to afford the healthcare itself, and then the power to make decisions over healthcare, and finally, the policy issues that enhance efficiency in provision of healthcare. And in so doing, I recognized the fact that the factors that affect access to healthcare and financing for persons with disabilities are similar for both persons with disabilities and those without. The difference is that persons with disabilities face additional challenges, some of which are directly related to their health, therefore complicating their ability to enjoy the right to health. In terms of the dynamics around health service provision and financing, I looked at four major issues. On the issue of health financing, we are not yet adherent as a nation to what was proposed in the Abuja Protocol, calling for governments to allocate at least 15% of its overall national budget to healthcare services. And right now, this situation is complicated by our system of governance, which assigns the function of health to both the national and the county government. Ideally, according to the fourth schedule of our constitution, the function of healthcare provision policy is a role or a function of the national government. Then county governments are responsible for direct service provision. Unfortunately, a number of hospitals, and especially the big referral hospitals, are still under the jurisdiction of the national government. And this complicates access to health care for persons with disabilities in a number of ways. That while they are found in rural areas, the specialized services that majority of them may need are still domiciled in health institutions at the national level.
Sorry, can someone turn off? I can't hear. There's a lot of background noise.
Thank you. I hope it's not in my background. Then the other issue is inadequate data on persons with disabilities and other health stratifications that complicate healthcare provision. And the issue of inadequate data is very important for us to note, because last year during the national census, it was the first time that the data on persons with disabilities was collected. However, the data has not yet been stratified into the different kinds of disabilities and can therefore not even inform healthcare financing and planning. Then another dynamic around healthcare service provision and financing is the exclusion of persons with disabilities in key healthcare entities that would influence health financing. I will highlight a few, and one of the most significant one is the health committee at the national level. Budgeting for various departments and various functions are done at committee level and approved at committee level. And for as long as there's exclusion of persons with disabilities at such a level within the policy-making framework, even the financing and allocation of resources becomes skewed. Then there are also other healthcare entities like the big specialized national hospitals, where the laws that form these institutions, mostly the parastatals, which are the key national government hospitals, do not make it compulsory for persons with disabilities to be included in boards, therefore limiting their ability to contribute directly towards financing of the needs of persons with disabilities. And now I would like to have a quick look at the constitutional and legal focus in terms of health financing. And I will focus on 5 main areas or legal provisions. One is the Constitution, then the Health Act, followed by the National Health and Insurance Fund, the Mental Health Act, and finally the Persons with Disabilities Act. When we look at the Constitution, there is the Article 24 of our Constitution that prohibits discrimination based on all grounds, including discrimination on the basis of having disabilities. That considered, the Constitution forms a strong basis for non-discrimination. And when we go further to Article 43, it advocates or provides for the highest attainable standard of health and also includes social security as a consideration for persons accessing healthcare. However, when we start moving to the details of the laws that enable this, we find that persons with disability still remain excluded in terms of health financing. My first focus will be on the National Health Insurance Fund Act. When you look at the National Health Insurance Fund, in overall, it is a fund aimed at enabling citizens to access healthcare. The fund provides for compulsory contributions in order for one to benefit from the healthcare services. And when we look at compulsory contribution, the people who are mandated to contribute compulsorily are employers. For persons with disabilities who are already disadvantaged in getting employment and those who are not employed, it becomes difficult for them to access the National Health Insurance Fund. Yet this is the government provided health social security program. Then another issue with this is the fact that for one to access the National Health Insurance Fund services, one must decide on the hospitals that they will visit.
Bernadette, you have 3 more minutes, please.
Thank you. For persons with disabilities, this may be complicated because some of the healthcare needs they may want may be limited to specific hospitals that are not within their jurisdiction. In addition to this, the fund does not provide for any form of part payment, and this disadvantages persons with disabilities who are not able to pay the lump sum estimate of $5 a month. Then we have the Mental Health Act, which is commendable in that it enables persons with disability to access mental health care without discrimination. And one commendable thing about it is that the admission fees to health facilities can be waived by virtue of regulations from the Minister of Finance. Therefore, to a large extent, it's the first law that directly protects patients with disabilities, and specifically mental health, not just all disabilities. Then critical to look at before I end my presentation is the provisions for health financing that can be made possible through the Persons with Disabilities Act. Most importantly, the Persons with Disabilities Act provides for a social security funding for persons with severe disabilities. This remains inadequate and continues to seclude persons who have disabilities, are not employed, and cannot afford to provide for their own healthcare services. In addition to this, the amount is so small that if an individual was to contribute towards the NHIF, they would remain with nothing substantive to take care of their other needs. That means that despite the Social Security Fund being provided, it is still inadequate to ensure that persons with disabilities, severe disabilities for that matter, can finance their health care. I will go to the recommendations. In my paper, I made the following recommendations. The first one is that it is important for persons with disabilities to be included at different policy levels in health financing institutions, both in terms of legislation and the actual administration and management of funds, that where the policies and regulations on accessing healthcare can be done. The second recommendation is there is need for the social protection funds given to persons with disabilities to consider a mandatory waiver for NHIF provisions, if not ensure that the social security money, part of it is assigned to the NHIF as a mandatory requirement. Another issue is in terms of devolution of funds for the healthcare system. Despite healthcare services being devolved, a lot of funds remain at the national level, yet the needs for persons with disabilities are at decentralized levels where the healthcare services are required. So the recommendation here is to increase healthcare financing so that county governments, for that matter, have greater control over funds meant for healthcare services. And then another issue which touches on what my previous presenter from Kenya said is in terms of access to reproductive health care, that we still have an issue on access to healthcare in general, reproductive health care in general, and women and girls with disabilities are more disadvantaged. Therefore, as the reproductive health laws continue to be debated upon, it is important that that the needs of women and girls with disabilities are put into consideration. And finally, considering the weak systems and low financial provision, it is important that the state enhances private sector involvement in provision of healthcare services for persons with disabilities using innovative methodologies, for example, tax considerations and other forms of benefits in order to promote access and financing of healthcare to persons with disabilities. Thank you very much.
Thank you very much, Bernadette. I note your three main issues, questions around affordability, power, and of course, policy effectiveness. And I really like your recommendations. I think your presentation in a way complements very well what Naomi presented earlier, and the importance of inclusion in policy formulation, inclusion in monitoring of the implementations of these policies, and then, you know, the need for policy protection and just safety nets, and again the role of private sector. I think it's something that we don't talk a lot about, but yes, private sector does have a role. I've been monitoring the chat, and one of the big points that is being made by several colleagues there is the issue about contributing and building data. Data for development, data for protection. And I think what, at least in my own little world and my work, what COVID has shown was the dangers and the confusion that the absence of effective data management and national information could trigger. You know, so we need to consciously have policies that addresses this issue of data and the need for government institutions to truly plan and accurately evaluate existing social program effectiveness and ascertain how effective they are and how they are responding to the needs of the vulnerable, especially persons with disabilities. We will now open up the panel for a few questions. If you know, Sensha and colleagues at the center will allow maybe another 5 to 10 minutes so that we can get some questions from participants. We have, as I mentioned, monitored the chat box for questions to start. But you know, please continue to add in your comments and questions as they come to mind. And if you want to say something, please use the hand raising function, or I'm not sure, maybe just come up and speak if you have a question or a comment that you want to make.
Can I jump in? This is Jake Efele from Nigeria.
Yes, go ahead, Jake.
Okay. Oh, I'm so sorry. Sorry, my TV is on and might be. Okay, so sorry about that. Well, it's the issue of language, and I think you've tried to address it, but it's very, very important because as advocates, as much as we are trying to advocate to ensure proper use of language, if we as advocates are using the same wrong thing that we're trying to advocate for people not to use, then it leaves a lot to be desired. So I just want to emphatically mention to everyone on this call, and especially our presenters, that the community is very sensitive to use of language. And I'm not saying this to castigate the last presenter, but I'm just saying it generally, that the issue of using phrases like people or persons living with disability puts the condition before the person. And there's a need for us to, you know, as much as possible, use the right phrases. And even in advising our government, you know, persons with disability, we are not albinos, we are persons with albinism, not persons living with albinism, because it's as a derogatory as it is calling us persons with albinos or person living with disability. I think this is very important for everyone to take note as advocates in our various fields, that if we begin to use the right terminology, we will further strengthen the advocacy and deepen the advocacy that we are all trying to do. Other than that, I want to thank the university for this wonderful initiative and for your courage to go ahead and hold this program in spite of the situation with the pandemic. I think this has been very, very good, and the attendance is commendable, and the participation is very effective. Thank you.
Thank you, Jake. Is there anybody else? Anybody, a quick question or a comment? Anybody
yes,
from a geography that has some very innovative health financing models that they would want to share quickly?
Well, let me jump in, just quickly say that I think the last presenter did great work. And, you know, the issue with health, health for persons with disability is a great concern of mine. And I am very sure that this particular challenge is not peculiar to just his group or just his country, is something widespread. I am from Ghana, and I see these challenges as, running through. And I believe that a lot of advocacy must be put into this particular, work, so that our children, especially those who are very vulnerable, are the children who are in schools. Now that we are advocating for inclusion, so we need to also look at children who are in schools, how issues with health is affecting their academics, affecting their attendance, and they are labeled truant children, because they are not attending schools, just because the health is a problem, accessing good health care is a problem. So we need to look at this. I want to finally say that, you see, the issue with terminologies is, I think that a lot of groups, have relaxed on advocating for some of these things, because you read literature and you find a lot of terminologies that are from the ancient, and then they are brought current. And I read a recent one, I read one literature that they were saying that we have not properly documented some of these things, so that it looks as if we are using them, even though they are not properly documented. So I think that proper documentation of some of these terminologies should be done, and that move should be done by associations of persons with disability. I am sure once that is done, it will be accepted clearly, and people will be encouraged to use the proper terms. Thank you.
Thank you. And I think that the point has been made about the power, just how much power language has. And the kinds of words that we use to refer to persons with disabilities. I think we are way over time, so thank you everyone for posting in your contributions, your comments, the lively discussions. Thank you to the panelists who presented to us today. Thank you everybody, and I can sign off and see you all for day 2 of the last session of today, and then day 2 of the conference tomorrow. Thank you.
Yeah, thank you so much, Afia, for the excellent moderation of that session, and to all the panelists of that session. So we are committed to trying to end at 5. I think it's been a long day of many discussions, and it would be unfair to keep you longer. So we are going to try and keep the session on time as much as we can. So the final session is looking at mental health law. And our countries are at different stages of reforming our mental health laws and policies to bring them to alignment with the Convention on the Rights of Persons with Disabilities. And hopefully what this session does is really, we can collectively reflect on where are we in terms of mental health law reform in our different countries. What are some of the strategies we can use to push and advocate for reform where reform has been slow. Yeah, and also what do we need to guard against, as we are reforming our mental health laws and policies? What are some of the pitfalls that could come about? So we thought that the case of Moya and others versus the Attorney General is a good segue into this discussion, because it helps us see how, the passage that Zambia took in terms of really getting to reform their mental health law. And last year they adopted the Mental Health Act of 2019. So to help talk us through the litigation that's happened, the case, you know, some of the strategies that advocates were trying to use, is Chipo and Felicity. So both Chipo and Felicity teach at the University of Zambia. Chipo teaches human rights and clinical legal education. She coordinates the Disability Rights Law Project. She's a practicing advocate, and she's also now currently doing her PhD at the University of Cape Town. So thank you, Chipo, and looking forward to your presentation. Chipo will be presenting with Felicity Kalunga, who has over 12 years of legal practice. She lectures administrative law amongst other topics, and is very active in terms of law reform efforts and working with the Zambian Law Association. And she's also currently doing her PhD with the University of Cardiff. And following their presentation, we will hear from William Aseka. So William is a human rights lawyer. He is currently with Validity Foundation as their African Advocacy Manager. I know they've done a lot of work around the continent on this issue. So we're hoping to hear from William on his reflections on the case, but more importantly, on some of the other strategies that they have been using to try to advocate for mental health law reform on the continent. So over to you, Chipo and Felicity. And if you could kindly try to keep your presentation to 10, 15 minutes, that would be great. Thank you.
Thank you very much, Innocentia. I will pick it up from there. I'll begin and then Chipo will end. If I may share the screen to show the outline of the presentation and how we'll proceed with it. So the outline is that I will talk about the background of the case, the brief history of the events leading to the litigation, and then a summary of the regulatory framework of the Mental Disorders Act, which was the subject of the legal challenge in the case that we're discussing. And then Chipo will talk about the litigation itself. To try and fit within the time that has been given, I'll just start by way of background to state that it is important for us to acknowledge first that litigation is just one of the many important steps that were taken in this process to reform the law on mental health in Zambia. So it is not the only, but one of the incremental processes that had to be taken. And then the second issue is that mental health is broader than law on mental disabilities, as it was previously called, or the mental health law. So it cuts across several legislative provisions. In the case of Zambia, we have like the health practitioners law, we have the public health law, and many other laws, including the constitution, that impact on mental health. So this is important for us to mention, bearing in mind that when Zambia enacted its Persons with Disabilities Act in 2012, it had a provision which said that any law before it or that is enacted after it that contravenes its provisions would be subject to it. Now, we had an opportunity to challenge this provision or to get an interpretation of the court about this provision. And in that Mwa case, unfortunately, the court disagreed with the provision or the argument that the Persons with Abilities Act had tacitly repealed other laws that were contradictory to it. So that means that the work is not finished with the enactment or repeal of the Mental Disorders Act. We would still have to look at those other laws that impact on the right to health of persons with mental disabilities. So I thought that's an important thing to say in the outset. So our discussion here is limited to the right to health of persons with mental disabilities, which we have defined as the right to attain the highest form of physical or mental health of well-being of a person. And it does not mean freedom from illness. And so our discussion focuses on the aspects of the case related to this right. So there are other many things that were discussed in that case, including, for instance, involuntary detention and other aspects that we will not talk to because of the time limit. So we'll focus on the aspects related to accessing equal access to mental health services and other health-related services, so both physical and mental. So just by way of background, and I would say that Zambia had a Mental Disorders Act of 1949, which was the main law regulating mental health. And because of that act, everything else around mental health was implemented around the provisions of that act. Now that act was based on the medical model with much of its focus on treatment and protecting the person with a mental disability from danger to himself or herself or harm to society. And so it had provisions to do with involuntary detentions and treatment without consent. So to challenge its provisions and its implementation, many actions were set in place. And it involved a lot of collaborative work, and most of the work began early on around 2007 with the work of concerted efforts from disability rights organizations, as well as other partners that we are working with, organizations of persons with disabilities. Self-advocates proved to work a lot. We had Mental Health User Network, which is an organization of persons with mental disabilities who had engaged first in research themselves and empowering persons with disabilities to enable them to collect evidence that would be presented in court. And there was a lot of collaboration, as I have mentioned, and this involved working with international organizations to do research. And one of the most important research work is the research that was conducted with MDAC, now Validity. I'm happy that someone from Validity will give a reflection of that. And that research proved very useful in highlighting the state of mental health provision and facilities in Zambia.
Please, what language do you want us to speak? English. My name is Rachel. Oh.
So just to highlight that the implementation of the Mental Disorders Act produced discrimination in terms of provision of health services generally, because persons with mental disabilities then were prevented from accessing general health services. So the Act had designated institutions for treatment or specialized hospitals for treatment of persons with disabilities. In the entire country, there were 6 according to the Act. And then apart from those 6, you could access mental health services in government hospitals, which prevented access to mental health services in primary health care. And even on the secondary health care level, they were restricted to those institutions. And this is what then produced the disparities in the implementation of health services. You would not find mental health services in other services that were not prescribed as mental health services. And in those prescribed institutions, other healthcare services were neglected. And part of the findings, just I wanted to highlight from the research of by Munza and MDAC at the time, that is now validity, just showed how there was a denial of healthcare, for instance, services in those institutions. So this picture, for instance, shows a woman who had received burns and had not been attended to for about 3 weeks, because in those specialized institutions, the focus was on mental illness. And so other health services were neglected as a result. So people in those institutions were denied access to other health services because of the regime that had been created, which separated mental health from other health services. And these other pictures show now how these institutions that were dedicated to the provision of health services were neglected to a point of dilapidation. You can look at the picture on the left is the Chipata Psychiatric Hospital, which was taken on 26 October 2012. And that showed the status of the beds there without mattresses to sleep on. And there's another picture there, which is showing another psychiatric hospital ward, which shows the dilapidated state of the hospital there in the toilets. So these are some of the things that the case then sought to challenge when it was presented before the court. So the litigants, among other things, sought to challenge the status quo that was produced by virtue of this act. So they sought the court to make a determination on their right to dignity, personal liberty, inhuman and degrading treatment, and then freedom from discrimination that was resulting, and the denial of access to mental health services. So I'll leave it there for Chipo to pick it up then to discuss the case. And I'll, Super, should I stop sharing the screen, or you? I think I should stop sharing and then Chipo will pick up from there. Thank you very much.
Felicity, perhaps you could, in the interest of time, just continue sharing that screen and then I'll speak to the slides.
That's fine.
Great. Thank you very much, and good afternoon, colleagues. Thank you for the opportunity to present. As Felicity has properly highlighted or given the background of the case, I just wanted to emphasize the fact that our litigants did have personal experience of the healthcare system and were able to speak to it and give evidence of their own experiences. The other thing that we had to deal with was the understanding of the courts, of the entire legal system of these experiences, and how do we make sure that the experiences of persons with mental disabilities were actually brought into the courtroom and reflected the kind of barriers that they experienced by the continued existence of the Mental Disorders Act. And so we, like has already been stated, challenged the involuntary detentions that persons with mental disabilities experience. And most of these were done at the hands of family members, community members, police, who often disagreed or did not understand either the fact that a person was in a mental crisis at the time, or were not actually in a mental crisis, but were trying to communicate their wills and preferences, and these were just not being heard. So yes, that is the first slide. So our first challenge was whether the Mental Disorders Act unconstitutionally and unlawfully permitted disability-based detention and involuntary admissions to prisons and mental institutions. And this is mostly because prisons were also being used as places where a person in a mental crisis could be taken. Particularly if an offense is alleged and the criminal process has commenced, the person with a mental disability would then be put in a prison facility. The court held that the principle of proportionality had to be applied when determining whether such detention is unconstitutional or not, because it was of the view that there are certain cases that would justify such kind of involuntary admission. And this is really one of the key things that is challenging, that any person who is subjected to any form of treatment must actually be able to give their consent. And because persons with mental disabilities were not engaged in their condition, in what was going on with them, however they presented themselves, is what determined to the person detaining them the need for them to be detained. It's very interesting to see that the court held that there needs to be a balance between competing considerations on detention and admission to mental health institutions, which appear to be involuntary on the one hand and affected a person's rights. In my view, there may be instances where it is necessary for the family, the community, or law enforcement agencies to have a mental patient admitted without their consent, especially where they suffer from severe disabilities or where it is obvious that an affected person is not capable of making an appropriate decision for their care and treatment. The decision to determine whether the detention or admission of mental patients to prisons or medical institutions is a medical question and cannot be determined by the courts. So whereas the court was reluctant to make an overall finding on involuntary admission, they were saying that the court was literally saying that there are instances where such detention, even though that it does infringe rights, the court also acknowledged, however, that there are instances in which people are with mental disabilities or persons in a mental crisis are able to give a decision on how they would want to be treated. And it recognized that in such instances, they should be given that opportunity to express themselves. With regards to discrimination, the court felt, and this is really discrimination that comes from involuntary admission, the court held that the Mental Disorders Act provisions that were cited by the petitioner were actually progressive. The courts felt that the fact that there were separate clinics or hospitals where persons with mental disabilities could be taken when they're in a crisis, it was a progressive thing. And it held that there is need to consider the economic social impacts, which remove the issues into a larger discourse rather than one of a legal type. Thus, I find that the Mental Disorders Act does not contravene the constitutional provisions on the rights to liberty and security of persons, but rather provides a platform under which all of these issues could be comprehensively reviewed.
Sorry, we need to slow down. Yeah.
I'm sorry, I'm too conscious of the time. Okay, noted, thank you. I forgot about the interpretation. My apologies for that. So basically, the court recognizes that discrimination could occur in the process of involuntary admission, but in certain instances, it could be justified. That is as far as the argument on discrimination went. In terms of the inhuman and degrading treatment that persons with mental disabilities experience in health facilities, the court held that people should be treated in a humane way and that there should be respect of persons with mental disabilities. However, the court also felt that petitioners have been admitted at that hospital and have real experiences of the facilities. And if inhumane treatment did occur, then hospital authorities contravened Article 15 of the Constitution. In order to prevent such reoccurrences, I hold that the authorities
Chipo? Okay, It looks like we may have lost Chipo. Can I ask William to perhaps get started, or I don't know if Felicity, you are able to continue whilst we...
I was going to pick up to finish off perhaps where Chipo left.
Yes, I think let's do that because, yeah. And if she is able to join back, then she can also jump in if need be.
Okay, so in terms of involuntary sorry, I was still learning how to respond to the technology simultaneously as I do this. So in terms of whether or not I think that was discussed. So I think the next issue is the access to healthcare services by persons with disabilities. And in this instance, the court held that it is incontrovertible that every person is supposed to be provided with healthcare services without discrimination. And that is to say that persons with disabilities must enjoy the same health range, quality, and standard of services and treatment as provided to others, and that there should be no discrimination whatsoever. And that it is a notorious fact that a number of mental health facilities in the country is limited, and so there is need for authorities to address the concern so that wherever possible, mental health patients should be able to access treatment at the primary level, as well as pay attention to equality and access. So this addressed the concern that because of the Mental Health Act, which provided for this provision of restricted places where access could be obtained, people were prevented from accessing healthcare everywhere. So the court made a pronouncement to that effect, so that authorities responsible should make access to healthcare services available to everybody regardless of their status, including persons with mental disabilities. One of the successes, of course, including the other incremental efforts that the disability rights movement had taken towards the reform of law, culminated into the amendment to the repeal of the Mental Disorders Act and the enactment of the Mental Health Act of 2019. You'll note that from my earlier presentation, I had stated that as far as 2014, government had indicated willingness to repeal the act and that there was a draft bill that had been prepared. This is what the government had also stated during the litigation, that there was a draft bill in process. And so they wanted the court not to compel or to make law, because Parliament is the right body to make the law, and Parliament had a bill in place. So this is the bill that then was enacted in form of the Mental Health Act of 2019, which has repealed and replaced the Mental Disorders Act of 1949, which was an archaic piece of legislation. And with regards to health rights, the Act has specific provisions that says that specific groups must always be taken into account in planning and implementation of health rights. So the Act prescribed, for instance, the treatment against a mental patient. It has some of the provisions that I would like to highlight that respond to some of the challenges that the parties had asked the court in the litigation. For instance, Section 7 provides for the promotion of mental health and preventive programs. There's a section 15 which provides for access to mental health services, and that is unlimited access for everybody. So that addresses the problem of institutionalization and prescribed institutions. The new act does not have that. So we don't have that prescribed list that we had under the 1949 Act. We have sections 16 to 18, which provide for the rights and responsibility of mental health patients. So the right to privacy, for instance, is provided for, the dignity of the patient and confidentiality. There are other progressive provisions. Part 3 provides for the National Mental Health Council, which should operationalize the operations of the Act. There's a Part 4 which talks about the standards for care and treatment. There's a Part 7 which provides for consent, how it should be given. Of course, some of the provisions are still problematic, and the parties are engaging in further research and lobbying with the government to see if amendments can be made, for instance, on legal capacity on Section 4, which is one of the most contentious provisions. Part 7 provides for admission, treatment, care. The Act also provides for criminal procedures and forensic. So there are different provisions, but I think to relate it to the litigation is that it does address quite a number of the issues that the parties had raised, and also to acknowledge that while the Act is a significant improvement from the Draconian Act of 1949, it still needs to be operationalized. I think that is yet to be seen. And also the effect that it has on other laws that regulate the right to health for persons in Zambia. And because the litigation said that these acts, even if they say that they have a provision that kind of entrenches them, courts are not willing to accept tacit repeal of previous acts. So we would still have to do a lot of work regarding the other laws that impact on the right to health of persons with disabilities, including like persons with mental disabilities, because much as this act is progressive, it still needs more work to be implemented. I think that should be all from us. Thank you very much.
Thank you so much to both you and Chipo for that presentation. And so some quick takeaways before I invite William to speak. Was your emphasis that, you know, mental health is broader than just the Mental Health Act, and that we need to be looking at other laws that have an effect on the health of persons with mental disabilities. Some of the strategies you shared that made your litigation successful were that it needs to be collaborative and it needs to be fully inclusive and ensure that the voices of and experiences of persons with mental disabilities are heard. And that we do need to take the courts along with us. We do need to ensure that the courts fully understand the experiences of persons with mental disabilities and why we're making the arguments that we are making. Otherwise, we risk getting a judgment that is not progressive. But I think interesting also, like some of the research findings that, you know, in most instances, and I'm sure that's true for a number of our countries, that most of our people can't access mental health services in primary health care, you know, a setting. So that does mean that they have to, you know, go out of their communities or travel quite far to access the services, and that those specialized institutions sometimes then neglect other health conditions. So I'm quite interested to hear in the chat room people's thoughts around the court's decisions on involuntary admissions, that it could be justified, and what are your thoughts around that? So I was just monitoring the chat, and Willen Holness was directing us to a decision made in South Africa on involuntary imprisonment. It's divorce versus the Minister of Justice. So she's put a link for those interested in following that up. And then I'll hand over to William. And William, I'm afraid you have a fewer minutes than I had hoped you would have. So if you could keep this to perhaps 8 minutes, and then we'll conclude and with a round of questions. Thank you.
Okay, thank you so much, everyone, for making the time to attend this particular presentation. And thank you for Felicity and Chipo for coming up with this discussion about Mwewa, and have been able to rightly point out about the issues in which were canvassed in that particular decision. Now, the whole idea about the decision was that I think for me, what was catching up or was the catchphrase for that particular decision of Mwewa was the whole concept about right to informed consent. Now, in this particular conference, we are speaking about the idea behind right to health. And most of the times when we are speaking about right to health, we not necessarily focus on people with psychosocial disability or with intellectual disabilities. Now, the idea about right to informed consent is simply that for a person to be able to access or to be subjected to a certain procedure in hospital or whatever situation, what we think about is that they need to have an informed consent. Now, why is that important in relation to Mwewa was that the whole concept of legal capacity or mental capacity was denied by the, or was denied, the petitioners were denied this whole concept. Now, interestingly is that the judges say that, you know what, you can be subjected to involuntary admission to hospital. I mean, it shouldn't be that controversial. Now, because of that, the Zambian parliament introduced the Mental Health Act of 2019, and of which I think Chip has been able to, Felicity has been able to point out the whole idea about Section 4 of that act. Now, Section 4 of that act simply conflates mental capacity and legal capacity. And why is that important, especially in relation to right to health, is because of the whole idea that if you cannot be able to make certain decisions, it's assumed that you do not have legal capacity. Now, that's important on right to health because whenever people are taken to hospital and it's assumed that it's in your best interest that the doctor is giving you a certain medicine or is subjecting you to a certain procedure. So that is the whole concept or the whole problem about Section 4 of the Mental Health Act, which currently validity we are supporting again Sylvester Kantoka and what is it called? Fred Waluia. So I think they're currently again in court to challenge that particular provision as to its constitutionality. Why is that important in all making the mental health reform in our different countries is that in most cases when we're speaking about right to health, we don't have a problem with anyone. Even those of us who do not have disabilities, when we go to hospital and we are asked about what medicine are we comfortable with, what thing are we not comfortable with, that same kind of procedure, as simple as it looks, is not afforded to someone with mental health disability or a person with psychosocial disability. In fact, it's usually assumed that the doctor is at a better position to present or to make, to decide about their mental health. So currently, as my previous participants have been able to mention, litigation is an important aspect which will add into conversation about mental health reform. It doesn't necessarily matter it's in Zambia or whatever country, but litigation is important because it brings out the whole issues about how does a person with disability, specifically a person with mental disability, exercise their right to health as provided for under Article 25 of the CRPD, which majority of our countries have signed and ratified. So that is quite important. So the other aspect about why the right to informed consent is important, especially in relation to right to health, is because it stops what we usually term as institutionalization of people with disabilities. Now, if you're to go to the case of Mwewa, there was all this conversation that, and I think Sylvester was able in his affidavit, was able to say that, you know what, several times I've been arrested and taken to mental health institution because of the assumption that I do not have proper decision-making skills. Now, institutionalization of people with disabilities simply amounts or whatever it is that happens in these institutions for one reason or the other, it amounts to torture. Now, I think we had the special rapporteur on right to health, and he spoke in detail about whatever it is that she'll be able to do as a follow-up to whatever it is that the previous rapporteur did. Now, the previous rapporteur in one of his reports is simply said that mental health institutions are actually breeding ground for torture. And why is breeding ground for torture is because of the different operations or activities which are given to people. Now, we all know whatever it is that is happening in these mental health institutions and why it's important, especially in relation to torture and the right to health. Now, as validity, what some of the things in which we are currently trying to advocate for is deinstitutionalization. What does deinstitutionalization mean? Deinstitutionalization simply means that rather than having people with disabilities taken to institution as a first option, we are simply saying that, you know what, we need to have other options on the table, such as community-based services. In most cases, and especially during this pandemic, one of the things in which has come out, at least as a good note, is that we have started having a lot of conversation about mental health. And we are speaking mental health, but in most cases, we are not necessarily speaking mental health as whereby you need to be taken to a mental health institution immediately you are suspected to have a mental health problem for whatever reason. So what we are simply saying as a community-based service, we need to have whatever services which are offered in these mental health institutions so that we can be able to realize the right to health. They need to be offered at a community level, at our primary facilities, which will be important. So those are some of the things in which we are thinking that if we were to have community-based services in this level, at the primary level, at the community level, it will be able to assist or to make the right to health for people with disabilities to realize it or to access it much easily. So that is something in which it's important. Now, just the session before this, the speakers were speaking in detail about financing. Now, one of the things in which we are currently also involved, which will help mental health reform, is trying to monitor budgeting for mental health, specifically people with psychosocial disability. Interestingly, an organization called Inclusion International has done a report specifically for people with intellectual disabilities, whereby they're trying to see what kind of funding goes to or supports people with intellectual disabilities. Now, in return, what we intend to do is we are trying to come up with a report which will try to focus what kind of funding does it go to people with psychosocial disability. Why is that important? That is important because most of the time, issues to do with mental health are usually not looked as social protection. They're looked at from a medical perspective. Now, for instance, in Kenya, issues to do with support of people with psychosocial disabilities, people with mental disabilities, is actually within the Ministry of Health. Why is that problematic? It's problematic because for a certain group of people with disabilities, they're still being viewed from the medical point of view, of which we all agree that under the CRPD, we were moving from the medical model of disability to a social model stroke human rights model. So those are some of the things in which we are much more interested, which will ensure that mental health reform is going to happen. Now, why is it also important? It's important because if you're to go to Article 32 of the convention, it simply provides that international donors who, for instance, support a lot of our projects, especially in low-income countries, are required to fund projects which are disability compliant. Now, I'm sure some of you are aware of this, that some of these international donors continue to support the existence of institutions. If we were to look strictly speaking of Article 19, Article 19 basically provides that everyone has a right to live in the community independently. How are they going to access their right to health if they're in a certain institution locked up? So these institutions are problematic, and because of all these aspects of why they continue to exist. It's also because some of our donors continue to fund their existence. Some of our countries with domestic funding, what they simply do is that they continue to open up more institutions. For instance, I think the other day in Kenya, what I heard from the Ministry of Health, especially the Minister for Health, he basically said that, you know what, we are going to open up much more institutions which are going to be serving, quote unquote, people with disabilities for one reason or the other. Now, that is problematic from different sense because number one, our countries have signed and ratified the CRPD. One of the conditions of the CRPD is that we need to be moving away from institutions to people be living in the community independently. How do you live in the community if your government continues to open up institutions? If the fund in which your donors, different donors are providing for our countries continue to support these institutions. So what we are simply saying, while on the other hand, we'll go at the UN level, at the African Union level, and say, you know what, we have signed and ratified the CRPD. If at all we need to sign the Africa Disability Rights Protocol, we will sign it. But on this other hand, what we are simply saying is that donors, you can come, continue to support our mental health institutions, continue to support whatever it is that we feel is going to assist or to contravene people with disabilities in one way or another from accessing all the rights as provided for under the CRPD. So the whole of this conversation, why it's important at the end of the day, as I summarize, is that mental health reform needs to be looked from a much broader perspective. Why is it also important? From a broader perspective that for instance, most of these donors who fund our countries cannot be held accountable. We don't have rules in which are holding them accountable. That's why we are thinking that, you know what, we need to come up with rules in which if, let's assume country X, which has signed and ratified the CRPD in their own mechanisms, okay, are still funding institutions in our country, are still funding what we call CRPD non-compliant projects. For instance, we have so many countries that we have donors who continue to fund the existence of special schools, which in one way or another contravenes Article 24 of the CRPD. So we need to be much more cognizant that if we are going to realize the right to health for people with disability, we need to ensure that we call out different stakeholders. Apart from our governments, we need to call out the donors who continue to fund projects which in one way or another continue to violate the rights of people with disabilities. So thank you so much. I think I'll open it up for discussion.
Yeah, thank you so much, William, for that emphasis around budget tracking and us thinking through, you know, what are donors funding? Is it detrimental to the implementation of you know, the right to mental health, and also really looking closer at our health budgets on what percentage goes to mental health. So I'm going to open up for just 2 questions because I know we are really out of time, and we thank you for your indulgence. I know that Alexis had typed out a question. Alexis, would you like to ask your question? And there was also a question that came up more than once, and any one of you can address this. It's around whether litigation can be counterproductive, whether, you know, the kind of backlash that could come with litigation, and how do you mitigate this risk, especially on an issue like this one, that there are many polarized views on mental health. So what is the backlash? You know, and how do you mitigate that? Alexis, please. Yeah.
Thank you so much, Anastasia. It's a pleasure, and I've enjoyed every presentation. To Felistas and the question with regard to, I wanted to ask, in a sense, you can hear me, right?
We can, but I think it might be helpful if you switched off your video. So because it's a little, it's a bit slow. So maybe if you switched off your video, we might hear you better.
I've done that immediately. Yeah, so my question was basically to ask the presenters on the Zambian law to say that,
Alexis, we can't hear you. You're breaking.
What are in Zambia, if they have any?
Sorry, we're struggling to hear you, Alexis.
Hello?
Hello, we're struggling to hear you.
I guess network. I was just trying, maybe you can just go to my question and they can, one can try to respond from the typed question. Thank you.
Okay, thank you. Okay, so you typed, you're asking, what does Section 4 of the Mental Health Act provide? And does the Act provide for advanced mental health directives? If they do, what is the regime like? So I know we might not have a lot of time to get into all the details, but I think Chipo and Felicity, you can answer as far as possible. And Alexis has provided his email, and is really interested in further engagement. And then William, perhaps you can take the second question around litigation and backlash. Thank you.
Hi, good afternoon once again. Just to respond to Alexa's question, Section 4 of the Mental Health Act is on legal capacity. And it does actually conflate, as was already stated, it does conflate legal capacity with mental capacity. So it is not a good provision at all. It does not provide for advanced directives. And in fact, I should mention that many of the grounds that were raised by the petitioners in the case were actually rejected by the court, save for the obiter, the progressive obiter dicta that we've been highlighting and speaking to. The other thing that I think is important to note is that a lot of what the court said was actually translated into what we are calling our mental health law of 2019. So you find that the spirit in which the court was recognizing the need for mental health services, the need for humane treatment in form of obiter statements were actually translated into protective provisions in the Mental Health Act of 2019. But the same way in which the court failed to recognize informed consent in all circumstances, failed to recognize consent to admission in all circumstances, the same way that happened is the way in which the act more or less assimilated. So the spirit, the purport, the object, so to speak, of the court mood in that judgment was translated. And so we find that legal capacity has not properly been dealt with in the Mental Health Act in the same way that the court failed to properly deal with it in the case at hand. So that is a problematic one. It's good that Sylvester and Tim are taking this matter forward, and they are going to litigate the legal capacity because we believe that it is the bedrock of all other human rights of persons with mental disabilities, including the right to health. I thank you.
Thank you, Chipo. In a sentence, please, William.
No, I think Chipo has been able to explain most of it, of which I don't think I can be able to add anything. I'll be diluting whatever she has said.
Thank you so much, William. Thank you so much to our panelists. Listening to you and then looking at some of the comments, there's certainly a need for a greater discussion around the issue. I think there's a lot of almost controversy, and like I said, a lot of different opinions on how we approach the reform and what that would look like. And we hope in future conferences we'll have an opportunity to discuss this further. So I wanted to take this time to just quickly thank everyone. Appearing in the screen is a poll just to help us get a sense of how you found the presentations and the discussions of the day. I know that at this point you're quite exhausted, but this really does help us in planning and improving our conferences. So if you can, just before you log off, please do respond to some of these questions or all the questions on the poll. And from my side, it's just to thank you all for staying until the very end and for your participation and to thank the sign language interpreters, Susan and Natasha, you're amazing. I think with all this talking, your hands must be quite tired. So really, thank you so much. To our communications team, Yolanda, Taruna, Simpiwe, and thank you so much for making sure that we're connected and that everything goes well. Tariro, Sabia, Diana, who are with the Disability Rights Units, really also thank you. I think Sabia's been busy with the tweets, so please do retweet. Please tweet your own thoughts on today's discussions. We will appreciate that. So I think that's all from us. We look forward to you joining us tomorrow at 10 a.m. Our first session is going to look at sexual and reproductive health rights, and it really promises to be another fruitful day of discussion. So we look forward to seeing you tomorrow, and have a restful evening. And thank you from all of us at the center.